Hello everyone, welcome to Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Let us start with the headlines and a brief overview of the top stories. We will then dive into full details and in-depth coverage of each update. The Supreme Court has asked West Bengal Police to produce post-mortem challan in the RJ rape and murder case. It has also directed protesting doctors to resume work and the state to enhance hospital security. The Supreme Court has dismissed a plea to stop India's military exports to Israel amidst the Gaza conflict. The Apex Court has held that an accused who is already in custody for one case can apply for anticipatory bail in another case. The Supreme Court has dismissed appeals of TMC MP Abhishek Banerjee and his wife against Enforcement Directorate summons in school jobs scam case. The Telangana High Court has directed the Speaker to decide in 4 weeks disqualification pleas against BRS MLAs who defected to Congress. The Allahabad High Court has granted bail to a man accused of supporting Hamas on X and opposing Indian government for backing Israel. ANI has filed copyright infringement suit before the Delhi High Court against producers of Netflix series titled IC814, The Kandahar Hijack. The Allahabad High Court has sought responses of Union of India and UP government on a PIL to formulate Uttar Pradesh transgender policy. The Supreme Court has issued notice on a plea challenging acquittal of Ram Rahim Singh in 2002 murder of manager Ranjit Singh. Starting with an update on the suo motu case over the death of a trainee doctor at the RJ hospital in Kolkata, which was listed before the Supreme Court. The court today perused the status reports filed by West Bengal Police and the CBI. The court was informed that 4 clippings of CCTV footage of 27 minutes were handed over by Kolkata Police to the CBI. Solicitor General Tushar Mehta, raising doubts about forensic reports, said that the CBI had decided to send the samples to AIIMS and labs outside West Bengal. During the hearing, Advocate Firoz Idulji, who appeared for the petitioners before the Calcutta High Court, brought to light some important points and discrepancies, like that the post-mortem was conducted after 6 p.m., which is contrary to the rules and procedure. The seizure was done from the crime scene before the FIR was registered, which cannot be done because the forensic team can visit the place only after registration of the FIR as per the new criminal code BNSS. So this means that the investigation has been severely compromised. Advocate Idulji further said that the vaginal swab was not preserved properly at 4 degrees Celsius, and that the clothes of the victim were not sent along with the body for the post-mortem. Taking note of these submissions, the court questioned Senior Advocate Kapil Sibal, appearing for the state of West Bengal, whether the challan which sent the body for post-mortem was available, because the challan would contain remarks if any articles were sent along with the body or not. Sibal replied that the document was not available in the records produced before the court today. The court then asked him to produce the same on the next date of hearing. The CJI said that the document was important because it has a column showing what clothes and articles were sent along with the body. At this, Justice J.B. Pardewala remarked that if the document is missing, then something is amiss. Today, the court was also informed that the doctors in West Bengal had still been protesting, which has paralyzed the health system. Senior Advocate Sibal submitted that no resident doctors were attending the outpatient departments. He said that 23 patients had lost their lives due to absence of doctors and 6 lakh persons had been denied treatment. The court then directed the doctors in the state of West Bengal to immediately return to work, and that if they returned to work by 5 p.m. tomorrow, no adverse action would be taken against them. The court also ordered the state to make hospitals safe for doctors. The state of West Bengal must take steps to make doctors feel secure, addressing their safety concerns. The matter has been posted for further hearing now on 17th September. Stay tuned. In the next update, the Supreme Court has today dismissed a petition which sought suspension of military exports from India to Israel amidst the ongoing war against Gaza. The plea was filed by former bureaucrats, activists, and senior academics, stating that the ongoing export of arms and other military equipment to Israel violates Articles 14 and 21, read with Article 51C. That is, foster respect for international law and treaty obligations in dealings of organized peoples with one another. The court said that it was beyond its jurisdiction to direct the government of India to not export materials to any country, as it was a matter which was completely within the domain of foreign policy. Advocate Prashant Bhushan, appearing for the petitioners, argued that if a national policy contradicts the constitution and the law, then the court can intervene. He cited International Court of Justice rulings claiming that Israel is committing genocide in Gaza. Bhushan said that India should not allow exports used for such actions, as it would mean supporting genocide and violating the Genocide Convention that India has ratified. But the bench, comprising Chief Justice of India D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra, held that foreign trade was a matter under sole domain of the executive. When Bhushan said that the United Kingdom government had suspended the exports to Israel after a letter was written by over 600 jurists. CJI then replied that it was done by the UK government and not the UK Supreme Court. The top court today also said that granting reliefs in this petition would require making findings on allegations against Israel, an independent sovereign nation. Since Israel is not under jurisdiction of Indian courts, this would pose a jurisdictional issue. In a significant judgment, the Supreme Court has held that an accused who is already in custody for one case can apply for anticipatory bail in another case. A bench comprising Chief Justice of India D.Y. Chandrachud, Justice J.B. Pardewala and Manoj Mishra delivered the judgment in a case which raised a legal issue whether anticipatory bail can be granted in a particular case when the accused is arrested in another case. The court has now clarified that an accused is entitled to seek anticipatory bail in connection with an offence as long as he is not arrested in relation to that offence. Once he is arrested, the only remedy available to him is to apply for regular bail under Section 437 of CRPC. If someone who is already in custody for one crime fears being arrested for another separate crime, the new crime is treated as a completely separate case. This means that the legal rights and protections for the accused and the rules for investigation apply independently to the new crime. If the investigating agency needs to question or investigate an accused person for the new crime while he is already in custody for a different crime, they can ask for the accused to be remanded if anticipatory bail has not been granted. However, once the accused gets anticipatory bail for the new crime, the agency can no longer ask for remand in relation to that new crime. On the other hand, if a remand order is given before the accused secures anticipatory bail, the accused can no longer apply for anticipatory bail and must instead apply for regular bail. The Supreme Court has today dismissed appeals filed by Trinamool Congress MP Abhishek Banerjee and his wife challenging the Enforcement Directorate's summons in relation to a school jobs scam case. The duo, which claimed Calcutta to be its ordinary place of residence, challenged the ED summons, which required their attendance at New Delhi. The petitioners had argued that Section 50 of PMLA only indicates substantive power of ED to summon but does not provide the procedure for exercise of that power. So, the procedure for summons should be as per CRPC. The petitioners also highlighted that as per proviso to Section 160 of CRPC, a woman cannot be summoned beyond her place of residence. Therefore, as per the summons, they can be asked to appear only in Kolkata, where the offence is alleged to have taken place, and not in New Delhi. The bench, comprising Justices Bela Trivedi and Satish Chandra Sharma, while rejecting their arguments, noted that Section 71 of PMLA gives it overriding effect over other laws. It said that provisions of PMLA will prevail over CRPC in relation to summoning of a person. In another update, the Telangana High Court today directed Speaker of the State Legislative Assembly to decide upon disqualification pleas preferred by BRS and BJP MLAs against defection of 3 BRS MLAs to the Congress party within 4 weeks. They approached the court questioning inaction of the Telangana Legislative Assembly Speaker to decide on the disqualification pleas. The 3 MLAs were elected on a BRS ticket but defected to the Congress party, which is currently ruling in the state. The council representing the defecting MLAs and state had questioned maintainability of the writ petition. The bench comprising Justice B. Vijay Sen Reddy stated that since there is no information as to status of disqualification petition pending before the speaker, therefore a case was made out by the petitioners for a grant of relief. The court therefore directed the Assembly Secretary to place the file of disqualification petitions before the Speaker, where the Speaker was instructed to decide on the pleas within 4 weeks. While disposing of the petitions, the court indicated that the case would be reopened suo motu if the Speaker fails to decide within 4 weeks. The Allahabad High Court has granted bail to a man who allegedly expressed his support for Hamas on the social media platform X. According to the allegations made against him, he made a post wherein he supported Hamas and showed his resentment against the government of India for supporting Israel concerning the ongoing Israel-Hamas war. He was booked in the FIR under the IPC and the IT Act for public mischief. According to the prosecution, tensions arose in the village of Shanghai due to his post. Seeking bail in the case, he moved the High Court, wherein his counsel argued that the allegations against him were totally false. A bench of Justice Sameer Jain granted him bail, noting that the alleged offences were triable by magistrate first class with a maximum punishment of 3 years and that he had been in jail for more than 10 months now. Asia News International, that is ANI, has filed a copyright infringement suit before the Delhi High Court against producers of Netflix series IC814, The Kandahar Hijack. The series is a depiction of the real-life hijacking of Indian Airlines flight IC814. It explores events surrounding the hijacking, which occurred on 24th December 1999 when the plane was en route from Kathmandu to Delhi. The aircraft was hijacked by Pakistani militants and was taken to Kandahar in Afghanistan. ANI has alleged that the series has used footage of news agencies showing the then Prime Minister Atal Bihari Vajpayee, General Pervez Musharraf and terrorists without the permission and license. ANI's counsel said that the show producer had approached ANI in 2021 requesting to use the footage, but no agreement was entered into between the parties. He further said that ANI did not want to be associated with the series in any manner. He added that in one of the footages, ANI's logo is visible, which amounts to trademark infringement. The counsel appearing for one of the show producers said that the footages shown in the series were obtained through 2 firms and over 1 crore was paid for the same. The counsel appearing for Netflix contended that the purpose of showing ANI's logo in the series was not to take advantage of the news agency's name and that the show glorifies pilots and forces. The matter was heard today by Justice Minnie Pushkarna and notice has been issued to the producers of the show. In another update, the Allahabad High Court has directed Union of India, the state of Uttar Pradesh and other ministries to respond to a PIL filed by the Kinnar Shakti Foundation. The PIL highlights severe discrimination faced by transgender people in India, including verbal abuse, violence and denial of rights. It argues that lack of recognition of transgender status prevents them from accessing civil rights and services. The petitioners state that despite previous representations, they have not received satisfactory responses. The PIL seeks creation of a transgender policy for the state of Uttar Pradesh, implementation of transgender Ayushman TG Plus card scheme, and establishment of a transgender protection cell. It also calls for resources for Garima Grey facilities, transgender toilets, and special drives for transgender recruitment in government jobs. A bench of Chief Justice Arun Bansali and Justice Vikas Budhwar has given the respondents 4 weeks to provide their replies and has scheduled the next date of hearing for 16th October. And lastly, the Supreme Court has issued a notice in response to a plea challenging acquittal of Dera Sacha Sauda chief Gurmeet Ram Rahim Singh and 4 others by the Punjab and Haryana High Court. They had previously been sentenced to life imprisonment by a CBI court for the 2002 murder of Ranjit Singh, a former manager. Ranjit Singh was shot dead because allegedly Ram Rahim suspected that he was behind circulation of an anonymous letter highlighting the cases of sexual exploitation of the female followers. The High Court acquitted them, citing doubts in the prosecution's case. Ram Rahim is already serving a 20-year sentence for rape and has been convicted for another murder. The matter is now being reviewed by the Supreme Court. A bench of Justices Bela M. Trivedi and Satish Chandra Sharma heard the pleas today and issued notice. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.